Richard Williamson. I'm an estate planning attorney. This is my 30th year as an attorney. So this video is informational. It's intended to let you know what the basics of estate planning are so that you can use that information either with us or with your own attorney, however you choose. So at the first level, the first document in an estate plan is the trust itself. Now, trusts can be confusing for people, but they don't need to be. So let me explain the difference in your planning choices. When you plan on who gets your estate when you're gone and who's in charge, you have two ways to do that. Wills and trusts both do the same thing. They both say who gets it and who's in charge, but how they do it makes all the difference in the world. So let's go through these two so you understand the difference. Wills. Wills are easy. You don't need a lawyer. You could sit at your kitchen table at night, take out a piece of paper and write down, if I die, everything goes to my kids in equal shares. Sign it. That's called a holographic will. As long as it's in your own writing and signed by you, that's a valid legal document. The problem is wills, whether it's an informal kitchen table style will or what you pay a lawyer to do a full formal will for you, all wills have to go through our court system. It's a court-supervised distribution of an estate, has its own name, probate. That's a weird word. We get that from British common law like 3,000 years ago. It's Latin. Translated, it means proving of the will, in this context anyway, proving of the will. So probate, but wills are easy. That's why people take that shortcut. Then there's this trust thing that most people have heard about. Heard it's a good thing, but they're not really sure why. Well, all wills go through probate, but the design of trusts are not to go through probate. But where a will can be easy, a paragraph on a page with your signature, your trust for me, an average trust for me, for let's say a married couple with adult children, it's going to be about 50 pages. That always surprises people because if it's a married couple and they have 2 adult children and everything goes to the 2 adult children, what's with the 50 pages? But for a trust to do what it's supposed to do, in the body of that, for us not to need court supervision, in the body of that document, you have to lay out all the rules on things like taxes, creditor rights, beneficiary rights, succession rights. You have to appoint somebody as the personal representative of your estate, grant them certain authorities, but at the same time cast upon them certain responsibilities and restrictions. But if we can do all that in the body of a trust, we no longer need the court system to be involved in the distribution of an estate at all. So your choices on planning are wills and trusts. All wills go through probate, no trusts go through probate.